being enforced, and what it means if you or someone you care about relies on a U.S. visa in any way. Today's immigration update centers on a major development that is unfolding as 2026 begins. The U.S. State Department has confirmed that more than 100,000 U.S. visas have been revoked since the Trump administration returned to office. This number represents one of the highest levels of visa cancellations in modern U.S. immigration history, and it reflects a broader shift in how the government is enforcing visa eligibility and compliance. A visa revocation means that a visa which was previously issued and valid is formally canceled by the U.S. government. When a visa is revoked, the individual holding it no longer has permission to use that visa to enter or remain in the United States. In practical terms, this can mean being unable to board a flight, being required to leave the country, or facing immigration enforcement actions depending on where the individual is at the time of revocation. It is important to understand that a visa does not guarantee entry into the United States. It allows a person to present themselves at a port of entry and request admission. When that visa is revoked, that opportunity is removed. Airlines are notified through government systems, and border officers see the revocation immediately when a passport is scanned. According to statements from the State Department, these visa revocations span multiple categories. They include visitor visas, student visas, and certain employment-based. Officials have stated that the revocations are tied to a range of factors, including criminal violations, overstays, security concerns, and failures to comply with visa conditions. What makes this development stand out is the scale. More than 100,000 visas revoked in less than a year is a significant increase compared to the previous year. Government data shows that this represents a sharp rise over past revocation levels, indicating a more aggressive and systematic approach rather than isolated enforcement action. For individuals affected, the impact can be immediate and disruptive. Students may find themselves unable to continue their education. Workers may lose the legal basis for their employment. Visitors may be unable to return to the United States after traveling abroad. In some cases, individuals learned of the revocation only when attempting to board a flight or when contacted by authorities. The administration has emphasized that public safety and national security are central to these actions. Officials have pointed to expanded vetting procedures and ongoing monitoring systems designed to identify visa holders who are no longer considered eligible. One such approach involves continuous vetting where visa holders' records are reviewed over time rather than only at the point of application. This means that visa eligibility is no longer treated as static. Even after a visa is issued, it can be re-evaluated based on new information, law enforcement encounters, or changes in policy priority. When eligibility is reassessed and found lacking, revocation can follow. International students have been among the groups most visibly affected. Reports indicate that thousands of student visas were revoked, sometimes tied to criminal charges, sometimes linked to alleged security concerns, and in other cases related to compliance issues. These actions have led to protests and legal challenges in several cities, with students and advocacy groups arguing that revocations occurred without adequate notice or opportunity to respond. Beyond student visas, the revocation effort coincides with other restrictive measures introduced under the current administration. One of these is the expansion of visa bond requirements. Applicants from certain countries may now be required to post bonds ranging from several thousand up to $15,000 as a condition of visa issuance. While refundable if visa conditions are met, these bonds increase the cost and complexity of obtaining a U.S. visa. Another element shaping the visa landscape is the use of presidential proclamations to suspend visa issuance for nationals of specific countries. Effective at the start of 2026, visa issuance to citizens of several countries has been fully or partially suspended with limited exception. These suspensions apply to new visa applications and are separate from the mass revocations already. For individuals outside the United States, these suspensions mean that applying for a visa may not be possible at all if they are nationals of a listed country. For those already in the United States with valid visas, the proclamation does not automatically revoke existing visas, but it does reinforce the broader enforcement environment. Legal authority for visa revocation is, well, pretty broad. Under U.S. immigration law, the executive branch has significant discretion to revoke visas when it determines that eligibility no longer exists. Courts have generally upheld this authority, limiting judicial review in many cases. As a result, revocation decisions are often final unless specific procedural violations can be demonstrated. For visa holders, this reality highlights the importance of ongoing compliance, maintaining lawful behavior, adhering strictly to visa conditions, and staying informed about policy changes are more critical than ever. Even administrative or minor issues can trigger scrutiny under the expanded vetting system. For those applying for visas in 2026, the process is expected to remain more stringent. Applicants should, anticipate longer processing times, deeper background checks, and additional financial or documentation requirements depending on nationality and visa category. The revocation of more than 100,000 visas is not an isolated event. It's actually part of a larger enforcement strategy that includes tighter screening, expanded monitoring, increased bond requirements, and broader use of executive authority to control visa issuance and validity. Regardless of where one stands on immigration policy, the practical effect is pretty clear. Access to U.S. visas has become more conditional, more closely monitored, and honestly, more vulnerable to reassessment than in previous years. Anyone whose plans depend on a U.S. visa should pay close attention to official announcements, policy changes, and compliance requirements as 2026 continues. Something major has shifted in U.S. immigration, and most people won't realize how serious it is until it affects them directly. There are travelers who booked flights, students who planned semesters, workers who assumed their paperwork was settled, and families who believed their visas were secure, only to discover that decisions were already made behind the scenes. No warning headlines, no individual notices ahead of time, just a quiet change with very real consequence. Today's update is about what has changed, how it is being enforced, and what it means if you or someone you care about relies on a U.S. visa in any way. That's all we have for this bullet.